This is the first time that a UK government has ever used a Section 35 order. We considered the implications with two lecturers in law, Dr. McKerrall and Michael Forna. Michael, the UK government argument is that this affects the Equality Act, does it?
Yes, I think so. I think the test here is whether or not there's been an amendment or a modification to the law as it applies to reserved areas. I think there's very clear examples of how this could happen, most notably in relation to schools because of the lowering of the age. The law in relation to whether or not single-sex schools can exclude will have modified that in particular. And then there's other areas in relation to the Equality Act in relation to things like single-sex spaces, pay claims about equal pay, and then also broader things about positive measures like female-only shortlists and things like that.
And Nick, what's your view on that?
Well, I think the issue is really about the confidence which the UK government have to challenge it, which they believe it affects the Equality Act. I think there is a legal question around that which needs to be answered, and the Section 35 as it stands doesn't immediately provide that. But I think the Scottish Government will challenge that, which will allow some of the legal issues around whether or not the Equality Act is modified to be tested in court.
Could somebody with a Scottish gender recognition certificate go to England and have that recognised?
Well, at the moment, not the case at the moment, given the laws in stasis, because it's not been given royal assent. The proposal is to suspend it, so that won't happen. But yes, the idea would be that a Scottish recognition certificate, as it is from other legal systems around Europe, would be recognised in England.
How significant is it, Michael, a Section 35 order has been used the first time in devolution?
Significant in the sense it's the first time that it's been used, absolutely. In another sense, it's a part of the ordinary working of the Scotland Act. This has been a part of the devolution settlement since it began. And so in that sense, it's a question of whether or not the test has been met and whether the political decision to make that has occurred. And so in that sense, we're dealing with the ordinary operation of the Act rather than something extraordinary.
I'm not sure I agree with that completely. I think this is a bit of a nuclear option. It's never been used before. It's being used in a way to deal with a political subject, which is a disagreement on the extent of gender recognition in Scotland, rather than a legal issue. I think if it was a legal issue, the court should decide it. I think this is a political imposition. It's not a veto, because I think the Scottish Government will bring a challenge to it. But it has the effect of a politician saying the Scottish Parliament can't do this on legal basis, which has not been tested yet. So I think there needs to be a court action to do that. But I don't think it's ordinary business. This is an extraordinary operation. Even though it's in the Devolution Act, Scotland Act 98, I don't think it was designed to be used for purposes like this.
So that's the option that's available to the Scottish Government, take it to court?
Yes, the Scottish Government can bring an action of judicial review in the Scottish courts, in the Court of Session in Edinburgh. The basis of judicial review happens. And that can happen because this is a government order. If it was legislation from Westminster, it couldn't be challenged in court. But because it's an order of the government, it can be subject to judicial review. Whether it's ultra vires, that means beyond the powers of the UK government to do it. And that's the point that Mike was making about whether or not this modifies reserved matters, whether it modifies the Equalities Act, which I think is open to question.
Calls tonight from some MSP, some politicians, that the UK and Scottish government should talk and reach some sort of compromise. Is that likely, given the position we're in? Is that possible even?
I think it is possible. I mean, I think this kind of picks up on the point that was made about the fact that this is in relation to quite significant political questions, but the tests that have been met here are very clearly legal tests, and so the question is about the operation of the law, and that can be resolved by reference to the kind of agreements that could be come to from both the Scottish Government and the UK Government on this.
Yeah, just as they are legal tests, but it's not been challenged by lawyers. Politicians have made the call so far. The Scottish Government have had legal advice, as has the Scottish Parliament, which is in direct opposition to what the UK Government's legal advice is. So why do they get to top what the Scottish Government and the Scottish Parliament's legal advice was? That's a political question. So I think this needs to be resolved in court.
It is also a legal question in the sense that they get to do that because the Scotland Act says they get to do that.
Yeah, but that means that the UK Government's view of law is untested by courts, and they get to assume that they've got the right answer, which I don't think is proven yet.
Yes, I think you're right on that, although the interesting point about this power is that it's one of the few powers that can be exercised by a government that is implemented for political reasons, but where there is a requirement in the Act for them to publish the reasons for why they've done that. And that is specifically designed to ensure that, one, this power is not used all that often, and two, it is subject to proper legal controls should it be challenged.
OK, and I'm afraid there we'll have to leave it. Michael and Nick, thank you both for joining us.
Thanks, Jim.